Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
Here we are back with one of our biggest episodes yet, Harry Plotkin. I think our guest today really is a true Hall of Famer in this profession, someone who, when you hear about trial lawyer, the name just always comes up of kind of who you look up to, who you see out there just getting consistent, huge verdicts. He's a Hall of Famer, like I said, has gotten 7, 8, 9-figure verdicts, 10-figure verdicts. That's right. God.
When's the 11-figure verdict coming though, Gary? That's
Yeah, we have the great Gary Dordick here with us, someone I've looked up to since I was in law school, and really appreciate you joining us here, Gary. I think this is it's really going to help a lot of people here and what you have to say about jury selection.
Well, thank you very much for having me. It's very nice, kind words. I think all of us have to give back. I had folks that I looked up to that were kind to me with their time and shared things with me. And I think it's very important for all of us to share what we've learned. Most of what I've learned the hard way. I got punched in the face a lot. I walked into a lot of brick walls and didn't know what I was doing and didn't have the benefit of podcasts. I didn't have the benefit of the seminars and the training and the volume of books. And so we just did things to see if it worked. And when we got slammed and we lost, we're like, well, that didn't work. Let's try something different. And it was sort of feeling around with trial and error. People don't think of it, but if you look at people my age and my era of trial lawyer, they say, oh, what kind of technology did you use? Oh, how did you present your case? It's like, hey, shit, there was no technology. Cell phones weren't invented yet. There were no personal computers. Maybe NASA had a computer, but none of us had it. All we had was a pocket full of quarters or dimes so we could go to the payphone and call somebody who knew. There was no technology. So we didn't have the availability and easy access to information and easy access to good lawyers that might be able to share things with us. We'd go to the courthouse and watch and learn, and that was about it. So I am happy to be here and happy to share what I can to help the folks listening to this.
What was Gary Dordick's jury selection like in his late 20s?
Well, I know you don't want to spend too much time with war stories, but let me put it this way. I'll spend a minute or two to make my point. I tried my first jury trial 3 weeks after getting sworn in. I opened my own law firm 2 months after being sworn in, but 3 weeks later, there was a case. I was told to go down there and settle the case. Went down there and the judge said, are you ready for trial? I said, well, hell no. The defense said yes. He said, okay, jury's on its way up. I said, I thought we were going to settle the case. The guy's like, no, there's no offer. So the jury comes up and the judge asks me if I'd like to conduct voir dire. And I'm thinking, well, not really, but I guess that's what we do, right? So I strut right up. I'm trying to be the best lawyer I can pretend to be. And you know what? I think I did pretty well. I thought some probing questions. I have no recollection of what they were, but I felt pleased with myself. And I turned and I sat down and I looked around and beamed with some pride at the judge and defense counsel. And I thought, I'm pretty good at this. The judge said, is that it? And I said, yes, Your Honor, it is. And then the defense lawyer stood up. He asked all 12 jurors questions. I only asked juror number 1 questions. I did not know that you could ask all of them questions. When the judge asked me who I wanted to excuse, I'm like, well, can I ask the rest of them questions? And he said, no, that ship sailed. And that's pretty much how the whole trial went. So back then it was a tough learning curve, but I just tried to figure it out. And it was a lot of trial and error. But what people don't understand as well today is back then when we tried a case, we had like one doctor and they had one doctor and the trial took 4 days, 3 days. And that's how we tried so many cases. I'm somewhere between 150 and 200 jury trials. I don't think we're going to see that type of thing as much in the future because, I try to help my young lawyers try cases. And after 2 or 3 years, they have 3 trials, 4 trials that they can do on their own. But this is an art. It is a practice. If you want to get good at picking a jury, pick a lot of juries, look at a lot of people, see what it's like to pick a jury with a good judge and a helpful judge and a judge who does good voir dire themselves. Try picking it in a hostile environment with a hostile judge. Try doing it to the extent you can in federal court or different state courts around the country. The more you do it, the better you get at it. And if you don't do it enough, you will not be very good at it, period. You can have instinct and you can have a certain skill to it, but there's no substitute for actually standing up and picking a real jury. You can do some mock jury voir dire, which is helpful, but you really got to pick a jury to get good at picking a jury.
Yeah, I remember I was a defense attorney my first 4 years, and I remember my first 3 jury trials. I didn't know what pass for cause meant. I had no idea what those words even mean. And so every time I would just be like, yes, Your Honor, I passed for cause. Every single time. It took me like at least 3 trials to figure out that I actually I don't have to use all my strikes. I can actually get cause and I don't have to pass every time.
I don't even remember them asking me that early on in the trials. They probably did. And I was kind of like,
yeah, what do you...
Sure.
Yeah, that's what I said. I was like, I guess you're... Yeah, I don't even know what you're asking me.
Yeah.
I'm not going to argue with the judge.
Yeah, no, unless you think I shouldn't.
Yes, Your Honor.
Yeah, exactly.
In the beginning, I think since I was able to do a lot of trials, it's kind of funny. I was just trying cases because I had to try cases. I started my practice. I had seen Mike Pughs, who tried a lot of product cases, tried really hard cases. I met him when I was a law clerk in law school, and I thought that's what I'd like to do. He shows up as the gunslinger late in the game. He takes on the biggest, baddest defendants, and I thought, I'd like to do something like that. And so that's how I started trying cases. And it was just something where I would get a case, try the case, get a case, try the case. People were giving me the worst, crappiest cases because that's all they give me. But I could try 13, 14 cases in 1 year. And I saw a lot of juries. I was telling my son yesterday, he's in trial right now in Van Nuys and really frustrated with the way it's going. And I said, look, people don't know this because I guess I don't say it a lot. If you look at it technically, I probably lost 10 of my first 20 trials. Lost because either I didn't get it as much as they offered. They may not have been defense verdicts, or lost because I could have gotten them to offer me more if I would have tried. But I was just trying cases. And then after doing that for just a number of years, just by myself, sole practitioner, trying case after case, I get a letter from some consumer attorneys. I think it was the Trial Lawyers Association. They said, you're nominated for Trial Lawyer of the Year. I'm like, for what? I'm just out here pounding and swinging and rolling in the mud. And I'd hit Disney. I was, I think, the first one to beat Disney. And that was how I learned, hey, there's consumer attorneys. And then I was just doing my thing and someone said, hey, what about a BOTA? I said, what is that? They said, oh, it's this trial lawyer organization, but you have to try 20 jury trials. Back then it was 20. Now it's down to 7. You have to try 20. I'm like, I did that in the first 2 years. No problem. I got 20. And so I became more involved and I saw that there were more seminars and there were more opportunities to learn. So,
and now you'll be a president. You're president of a BOTA.
Incoming president of the Los Angeles chapter. But hey, enough about me. I guess let's talk jury selection, huh?
Sure. One question I wanted to ask you, Gary, because one of the mistakes I see made a ton, and not a lot of lawyers understand this, some go through their whole career without realizing this, is you never want to rely on letting your jurors self-diagnose their bias. Like, you can sit there all day long asking all these questions, like, are you biased? Do you have a problem or issue with this or with that? And then they tell you, and that's fine to get rid of those people, but are the rest of the jurors great? And I always tell, like, some jurors think that they're totally fair and unbiased, and they're totally wrong. So you as a lawyer have to do that too. And I remember you telling me this story that always stuck in my mind about asking about feelings of sympathy for a defendant, right? And I don't know if you want to tell that story, but you remember what one I'm talking about, where, you have some jurors who are like, I feel a lot of sympathy for the defendant, and some who are like, nope, not at all. Do you just strike the ones who feel sympathy and keep the ones who
Yeah,
don't?
that's a good point. But, I think it's important to understand that you have to explain bias a bit to the jury. Because if you go up to anybody, strangers that show up for jury duty, they're trying to get back to work by noon or get home by 12 o'clock, and then they get called to a courtroom. Then their name is picked. Then they're in the box, and then they're like in the fishbowl, and they sit there, and suddenly you say, "Hey, how much is the death of a baby worth?" They're like, "What did he just ask me? What? Death of what? Who? My baby? Who's baby?" And, you know, lawyers don't have a feel for what it is to be a juror. And, you have to talk to them and let them get comfortable speaking, warm them up a little bit with speaking, talk a little bit about bias not being a bad thing, that everybody has likes and dislikes. What we're really talking about is, in your life experience, have you come to think a certain way about things that might make you great for the case next door, but maybe not the best juror for this case? That's kind of what we mean by bias. It's, strong likes and dislikes, strong opinions. And so I think you need to get people comfortable with talking about how they feel about things. And I know the basics everybody talks about, in the old days when somebody would say something we didn't like. "Oh, I think there should be tort reform. Oh, you lawyers, I know you just want, back then it was hundreds of thousands of dollars." And we'd be like, "Oh, Your Honor, Chambers, let's talk to this one in Chambers. This is a troublemaker." And now, of course, we've learned to thank that juror for their negative opinions we may not like, and telling them, "Well, that may not be music to my ears, but I thank you so much for sharing, because that's exactly what we're talking about. Because you are involved in a lawsuit, sir, you have strong feelings about them, it seems. I appreciate you sharing. And what you said was you'd have a problem with being on a jury that awarded a lot of money because of your experience. And obviously, you're working to get cause, but you're encouraging the people to talk. You're encouraging them to say things that we may not like or may not, we used to think, don't let everyone hear it. But if you look like you're hiding something from the panel, you're going to lose credibility. And once the person said something negative, they all heard it. So address it, deal with it. And one of the best things you can do is take that opinion after embracing it and ask who else has the same feeling or similar feelings, and then get a discussion going around the whole panel. Like now it's you and 12 or maybe 18 or 24 of your buddies just hanging out talking about it. What do you think? What do you think? What do you think? And then always flip it the other way. Okay, this gentleman thinks there should be limits or caps, even with a drunk driver, even with this. Show the unreasonableness of it, perhaps, and then say, who has a different opinion? Who thinks that maybe lawsuits are a good thing? Or who thinks that damages, that people should be fully compensated for all of their suffering? And you kind of get an idea who you're going to call on, because you've heard from them for a while. You've talked to them for a while. You've listened to what the judge says. And then you find a nice person there and say, "Ma'am, what do you think?" He says, "Well, I disagree strongly. I disagree. I think someone should be compensated. I've had chronic pain, and I'll tell you, no money would be enough for me." You say, "Well, thank you for sharing that view. Who agrees with Ms. Jones?" And you can then get a great discussion, because, so many lawyers like to hear themselves talk, but they don't listen that well. And as a trial lawyer picking a jury, it's not just listening to what they say. When you're dealing with subjects like racial bias and, discriminatory conduct, most of it's in the body language. No one's going to admit they discriminate against somebody from the Middle East. They're not going to admit they discriminate against people that don't speak English, but a lot of people do. They don't hear their testimony on a level playing field, but bringing out that bias is very difficult.
there's three really good topics. I want to hear kind of exactly how you address these, because I've seen you address things like alcohol really well, which I want to get to. So the person who says they have prior similar injuries, which I want to get to, but also let's just go start from the last point you made on, you have an immigrant doesn't speak English, or you have someone from the Middle East, maybe wearing a burqa. I don't know. Who knows? Whatever your client is, how are you specifically addressing that for the jury?
Number one, I used to not be a fan of questionnaires, and now I am. I used to think that I'm better at gauging juror attitudes and getting cause than the defense is. And if we use a questionnaire, it sort of levels the playing field, because even not a very good defense attorney at voir dire gets a ton of information right there, almost enough where they can pick the jury based on the questionnaire. But of course, as Harry will tell you, we get questionnaires, and generally I get them on paper and I hate them all. And then I stand up and start talking and I love them all. So the questionnaires can be a little bit deceiving, but it's helpful. But on bias, I tried a case downtown for a woman, Middle Eastern, from Iran. And I put on the questionnaire. I wanted to find a way to elicit the bias without making it difficult for someone who has the bias. So I phrased the question: how many of you think that people from the Middle East, in particular Iran, are less trustworthy in business? It's a harmless question. And so I told the judge, if anyone answers yes, they're summarily disqualified. And the defense objected, and the judge said, well, why would they be summarily disqualified? I said, oh, it's easy. Let's rephrase the question. How many of you think Black people are less trustworthy in business dealings? Judge's like, oh, I see your point. Anyone who checks yes, no questions, they're dismissed. So we lost 5, I think, on that question alone. So that's one way. Nowadays, I think with the Trump administration and everything that's happening with the border, I think you're going to have more trouble with people that are Spanish speaking and to them might appear not to be legally in this country or from this country or born in this country. And it's much harder to find that kind of bias. I would ask the questions in a questionnaire about their thoughts about people that don't speak English, people that will testify through an interpreter, and see. But mostly on those questions, I always find the bias in the body. And when I ask, does anyone have a problem with the plaintiff testifying in Spanish through a Spanish interpreter, I get this, the or the something, and you have to call them out on it.
Harry and I have talked about this. We had a trial, the same thing. The plaintiff had lived here for 35 years, never was going to speak to an interpreter. That bothered, the only people it bothered the most was 4 Hispanic women whose dads learned English after being here a very long time. That bothered them the most. So it's not always the usual suspects you think of who are going to be the most biased necessarily, right? So it's almost, you got to hit that question. You can hit that question pretty head on.
Well, that's an interesting point. Now, for our program here, we're really slicing it very thin that most people may not even understand. But we have a tendency, I think, as trial lawyers to work on broad assumptions. All doctors and medical people are bad for PI cases. Healing arts and teachers are good. We have these stereotypes that we try to follow, and to a certain extent, we have to. Stereotypes often prove accurate, but believe it or not, in talking to a lot of my friends that try cases, particularly Hispanic lawyers, they're finding the educated Hispanic jurors are the most difficult jurors on uneducated Hispanic plaintiffs that don't speak English or speak English but have gotten in some trouble. For example, on civil rights cases, if you talk to lawyers that try them, they get rid of every law-abiding, working Hispanic juror, because it seems to be their attitude is, we came to this country legally, we worked hard, we work hard to establish our community, the reputation of our people, and you guys are ruining it. You guys come here and break the law. You guys don't learn English. You don't acclimate to the community. And they're the harshest jurors ever. Whereas most people think people that have similarities will take care of each other.
Exactly.
That Hispanic people will take care of another Hispanic person. And in that case, it is rarely proven accurate.
Harry, I want to see that. Yeah, I want to hear your. I mean, you're in trial more than anyone, right? So,
Right.
are you seeing that?
Yeah, the same thing applies, not just to that, to any situation where, a lot of times lawyers will think, I want people who are like similar and they can identify with my client. But you know what? People who are in the same shoes as your client are judge them more harshly. Motorcyclists are often the worst for another motorcyclist. They're like, I know this is dangerous. I take a million precautions. I never would have done this and that, and I can't believe he got in that accident. I mean, and it applies to everything. Like, and it goes both ways. I have had cases against, trucking companies, bus companies, any commercial vehicle. If you get like a juror who is like an absolute Boy Scout about safety as a driver, they are like the best jurors for you. So they will judge the defendant harshly. So you got to listen closely. You're right. Don't assume just because they're like your client, they're going to be looking at them even harshly, and they know what it's like, and they know what they feel like they can do to keep themselves safe. I like an example, another great one. Anytime I work on a PI case where the plaintiff, there's maybe some comparative fault, right? Or at least alleged comparative fault. One of my questions is like, anybody here work in a really dangerous job where you have to be, your head's got to be on a swivel and you got to be, because those are the worst people. You might think, oh, those people would be great. They understand danger and safety and potential injuries and risk. But no, they're like, hey, buddy, personal responsibility. I keep myself safe. I'm an electrician. Like I do a billion things. And if you screw up and you don't notice something, that's on you. So you're right, Gary. I mean, the best jurors for you who give the most damages are the ones who are like, I can't even imagine being in that situation. Like if you work in a cushy desk job, you're like, I expect my workplace to be safe. I'm shocked if I hear, about an unsafe work condition. So, yeah.
The do-it-yourself handyman type or the guys that work in those kinds of construction fields are often not good jurors for plaintiffs because they don't trust that anyone else is going to take care of their safety. They don't expect anyone else. They don't expect them necessarily to make a safe product or a safe roadway. They're always taking care of themselves. On your point about the motorcycle drivers, I would say this. Yes, they can sometimes be very difficult jurors for other motorcyclists, but all things being equal, I often keep motorcyclists on my jury because, I'm a rider myself. I try a lot of motorcycle cases, and it is a them versus us. We're a very small minority that ride motorcycles. Cars are out to get us, and they know cars never see us. Cars always blame us when they hit us. So I do like motorcycle drivers, but you have to talk to them about somehow they become, much more careful when they're in the jury box. But I do frequently like motorcyclists depending on their views. And also, I'll tell you this, it's another here, we're slicing the subtle points here. If you're a plaintiff, don't ever get rid of a motorcyclist on your panel because the defense is always going to do it for you because they're always going to be afraid of people on motorcycles.
Yeah, do it last. I mean, if if you know the defense is probably going to be worried about this person, save them for your fifth or your sixth strike or whatever venue you're in because 8 times out of 10 they will knock that person off. And same applies to all of the categories. Hispanic juror. And you're like, I feel like this person's going to judge my client harshly. Yeah, wait. I mean, a lot of times, 8 times out of 10, they'll strike them for you. Yeah.
Similar injuries. The person who also has had back problems but never got money for it.
Well, that's what I was going to bring up was in the same category is people with similar injuries. When I was a less experienced lawyer, if my client had a cervical fusion, I kept every juror with a cervical fusion. If my client had a knee surgery, I kept every knee surgery plaintiff because they knew what it was like to schedule the appointment and be scared and have surgery and recover. I thought, oh my God, they're perfect jurors. But what I learned as I became a little more sophisticated was it wasn't if they had the same experience as my client, it's how it affected them and how they dealt with it. My client 3 years later is saying, oh, it hurts so bad, I can't even put weight on my leg. And they're saying after 3 weeks, I was playing tennis again. That juror doesn't understand your client at all and will be distrustful of them, their injury, and their claim for money. So it's not whether they've had the same experience or same injury. It's how it affected them and how they dealt with it.
And almost worse than that too. If no other jurors in deliberation have had a similar surgery, that juror is going to influence them a lot more, being like, "Hey, I had this fusion. It really isn't that bad." Their opinion will carry more weight in deliberation.
Harry asked me to tell a story when we first came on, and I went off on a tangent, but it is, I think, a good point as we look at subtleties. So let me tell you about the case. I was trying a case in Long Beach, and I had a plaintiff that was very harsh, as a plaintiff would be. He was a very large, muscular guy who owned a body shop. He had had a prior felony, as bad luck has it, for insurance fraud. And he was just a rough, tough guy and a big guy claiming a back injury, which he had, and he had had back surgery. But he didn't come off particularly sympathetic to most people, and certainly not at first impression. I was begged by one of our CALA members to try this case for him, so I did. And the defendant was a housekeeper who was, interestingly, successful as a housekeeper in that she had at least one or two people working for her as a housekeeper, and she had a $100,000 policy on her car. It was a red light dispute. She spoke only Spanish, the defendant, and they refused to pay the $100,000. So we go to trial, and we're picking the jury, and she's a very petite, elderly, I'd say, well, shouldn't say elderly, my age, maybe she's probably 60. And during jury selection, I looked at the panel, looked like a great panel, largely Hispanic, Long Beach, but the defendant started crying during jury selection, sitting at the table, just crying. And it was a weird kind of experience when we were talking about, damages and can you award a significant amount? And she's crying. And before you know it, there's a Hispanic gentleman that seems to be a little emotional. There's a couple other jurors kind of emotional. And within a short period of time, about 6 or more Hispanic jurors, he stands up and he says, "Look, I don't think I can be fair." And I said, "Well, why not?" And he said, "Well, look, the defendant's crying. She's obviously upset you're suing her for all this money. You're talking about all this money, and she's crying. And she reminds me a lot of my mother. And I feel bad for her." Now he's crying. And then there's other jurors crying. And I said, "Well, how many people feel like that?" At least 8 people, 9 people, 10 people out of 12 raised their hand. I feel the same way. And so I stayed on my course and I asked questions, and they were great jurors. They were great jurors, except for the sympathy factor. And I asked them about it and, whether they could keep an open mind, and they said they'd try. So the judge says, "Mr. Dordick, peremptory challenges." He says, "Oh, challenges for cause." I said, "No." And I got this one. Cause challenges, Mr. Dordick. I said, "Yeah, none." And he said, "Okay, peremptory challenges." And there was one woman, Eastern European, who, when I asked her if she felt anything about the defendant crying, she said, "No." And I said, "Well, do you think it would affect you in any way?" And she looked at the other people like they're weak. "No." And the judge says, "Peremptory challenge?" I said, "Yeah. Our Miss Eastern European is the only one." And they looked at it like, "Are you," even referral counsel that was there, he's like, "Are you out of your mind?" And I said to him, I said, "Look, man, think about it. Our case is about giving money, potentially millions of dollars, to this big, strong, tough guy who has a back injury. If they don't feel anything about a 60-plus-year-old woman sitting there by herself, crying in a courtroom, if they don't feel anything for her, they sure as shit ain't never going to feel anything for our guy. That woman didn't feel anything for the defendant. She's not going to feel anything for us. So they were good people. They were expressing genuine, true emotions. So my only problem with that trial was getting them to understand that my client's legitimately hurt and entitled to money. So I kept them all. The defendant continued to cry throughout the trial. She was crying on the stand on cross-examination. I said to her, "Ma'am, are you crying because you heard the plaintiff's testimony?" "Yes." "And you know how badly he's hurt?" She said, "Yes." "And you see how badly he's hurt because you ran the red light?" And she said, "Yeah, I think so." And then this was the one that threw her and threw everyone. I paused, I wait for it, I build it up. She's sniffling up there. And I say,
Jesus.
"You want the jury to award everything that's fair, don't you?"
No.
And she's like, "Yeah." So
Wow.
On a fusion case on those facts, I think it was one of my largest verdicts. It was about 10 years ago. I think it was like $6.2 million. So, so the idea that you might run from another thing that's similar, and I think you guys should share your thoughts about it, is all the inexperienced plaintiff lawyers run when you use a judicial counsel questionnaire and the jurors check. They think verdicts today are either excessive or often too high. You have 6 choices, right? Excessive, too low, often too low. Everybody freaks out when somebody checks that box. You're like, oh my God, I was hoping they'd say too low. Well, they almost never say too low. And likewise, most people think generically when they show up that verdicts are too high. They think that because they never publicize verdicts that are reasonable. And they don't hear about all the reasonable verdicts. So it's our job as a lawyer to say, you marked the box, or I asked you about excessive verdicts and you said yes. You raised your hand, yes. Do you think that's maybe because of what you see in the news and what you read and what you hear? Oh, yes. Do you think that they publish all the reasonable verdicts? Do you think His Honor and the courtrooms all up and down the state, do you think that most of the time the jurors get it right? And do you think maybe that's the only reason? Now, granted, they're hearing me talk a lot, but I talk a lot if I want to tell them something, if I'm preconditioning them, essentially, properly preconditioning, because I want them to think about that. And then after I give them the stuff to think about, then I'm going to stop talking and ask them, what do you think about that? So they sometimes say in jury selection, don't be the lawyer shouldn't be talking the whole time. True. But sometimes you have to get a message out. Sometimes you have to educate. Too many lawsuits? You talk about it, you say, how many of you think that sometimes lawsuits are good for society, like making products safer or roads safer? You're saying a bunch, and then you turn it around. What do you think? What do you think? What do you think? But I'd say I never excuse a juror for they think verdicts are excessive or often too high by itself. Now, if then talking to them, the rest of what they have to say is miserable, then that's just the icing on the cake. But for the most part, many times when someone says that, they're like, I don't know, I just kind of checked it. I kind of heard my friend got hurt, or I saw a TV show. Most of them don't have any foundation for it, don't believe it strongly, and are just as easy to say, yeah, you're right. So it's something to be aware of.
So are you using a questionnaire on every single trial now?
So what happens is the old school thought with questionnaires from judges was that, oh, they take up too much time. We don't have time for a questionnaire. So if you're doing a simple auto v auto case with nothing of any real significance, it's a back injury, a neck injury, you don't need a questionnaire, and the judge isn't giving it to you. Most of my cases have some degree of emotional distress, psychological injury, TBI that has a psych overlap. I tell the judges, the judges don't know. I tell them day one or at your final status conference, we're going to need a questionnaire. And they say, why? I said, well, we have my clients on psychological medication, antidepressants. We have a psych claim. I want to know about their experience with depression, anxiety, PTSD. I don't think, Your Honor, it's fair to ask them in front of everyone else in open court. So if we have to go into chambers, that's going to take 10 times as long. I also, generally, if you have an issue, like we said, with your client not being from this country or a witness being through an interpreter, those are sensitive subjects. So the truth is, I often find a reason to use a questionnaire because I get so much information that they're not going to let you ask. The questionnaire has, what do your parents do for a living? What do your kids do for a living? Has where you were born? What's your date of birth? It has their full education. And then you add, that's the judicial counsel questionnaire. So most judges will let you use it because it's the judicial counsel. Judge, it was approved by people smarter than us. They tell us to use the judicial counsel. And then I tell them, Your Honor, you'll see at the end, it's designed to add supplemental pages. That's how it was intended. So here's 2 pages of questions, things that you want to know about, unique to your case. Are you a property owner? A landlord? Do you have rental property? Or what are your views on police or corporations or depression or molestation? So I like to use them, and I tell the judge, it'll save time. You have to be prepared. You have to get the questionnaire approved by both sides and the judge before the day of jury selection. You have to show up with 60, 70, 80 copies. You have to bring the pens. The nuts and bolts of a questionnaire are the lawyer brings the pens. We bring clipboards. We bring pens and we bring copies and we say, Judge, it's all done. We arrange for a copy service to pick them up at the break and then send them by email to defense counsel, to us, and to the court. And then we bring the originals back. So we tell the judge, while we're rolling, it's not going to cost time, but you will get, and if you haven't looked at the judicial counsel questionnaire, those folks listening, get it, print it, read it, and if he won't give you or she won't give you, your judge doesn't let you use it, those are great questions to ask. And the judge can't object to those questions or sustain an objection because those are the judicial counsel questions.
All right. So want to thank our sponsors again. The first one is Verdict Videos. Kelly Deutsch. If you don't know Kelly Deutsch and Verdict Videos, welcome to the plaintiff bar. I know that, for Dan and myself, we work a lot of the same cases. I know for my wife and I, we have focus grouped their videos in focus groups, and jurors have loved what they've seen of these things. I've seen the increase in value and the settlement value of these cases is sometimes tens of millions of dollars more after the jurors watch their settlement doc videos or day in the life videos than before they watch the video. And day in the life videos, I don't know if you use them, Dan, but they're not just for trial. Settlement videos for mediation are an effective tool for trying to settle cases pre-lit too. I'm sure you use both of them.
Yeah, I mean, the best thing about working with someone like Kelly is that you're not handed off to some, other person, or you're just dealing with projects. Like you will get Kelly's cell phone. She knows how to talk to clients, and I think that's one of the hardest things when someone's to be invited into their home. She'll talk to the client. She'll sit down with the client. She knows how to tell a story, and she's just such a wonderful person, like truly empathetic, compassionate. She really understands what a client's going through, and that shows through in her production. And she's wonderful. We love her. She's just she contributes to the community. I know through LATLC, the charity, and all that. She's just a great person. Very easy to work with. Great pricing, and really will add a lot of value to your cases.
And I know what a lot of lawyers that I talk to love most about Kelly and Verdict Videos is they are always honest about whether they can help or not. I know there's cases where she has said, I don't think I can in this case, but I know that she's told me, our motto is video can hurt you as much as it can help you. And so I know she is actually cares and is strategic about how she can help in these cases.
Which is very true. I think in general, like everyone's like, oh, I need to have the best animation. I need to have this, that, and the other thing, sometimes less is more. And again, it's great. It's important to work with vendors who are going to be straight up with you and who are going to be honest, like Kelly, and not just want your money from the case. Like she will be straight up, and those are the best vendors to work with. Another wonderful sponsor I'd like to thank is my dear friend, Melissa Baldwin from Baldwin Settlements. She is a structured settlement broker. She's fantastic. She's one of the first people I met when I became a plaintiff's lawyer, and has just given back, just great advice. She's another one of these people you can call and just, get some advice, and she'll really go out of the way to help you out. She supports CAOC, CALA, all the, AAJ. She's a huge sponsor of all these organizations. Her and her structure team work tirelessly with the attorneys and clients, and she really makes the hard fought result easy for the client. I mean, I had a very tough case from someone who was basically homeless, and she was able to make him understand. He did not have any education to speak of, barely spoke English, but get him to understand how important it was to structure the money, because a lump sum and the many millions of dollars just would not have been good for him, given he had some issues with drugs and all that. She was able to speak to him at his level and get him a structure that really set him up for the rest of his life. And she was willing to work day and night, anytime, weekends, just to help get it done and get the best rates she can for the clients. So, and she also does not just structure. I used to think, I'd be like, look, when I was just starting out, my cases aren't big enough for you, Melissa. She's like, no. Like it's not just for the 7-8 figure settlements. It's really for all clients who just need some help to structure. And she can also structure fees, which is great if you want to put a little bit away for yourself and your family later on. So call Melissa Baldwin from Baldwin Settlements. Really great person, great friend. These two sponsors are just wonderful women that I really respect, and they run great businesses and good people. And lastly, we just again want to thank Law Pods for making this possible. These podcasts, their whole library of attorney podcasts, truly help, all of us get better. And I highly recommend you just listen to them. I put them on in the car. I'm listening to all these trial lawyers throughout the country with all the experiences they have. And it's just such a great avenue because we can't make it to courtrooms all the time, but we're hearing from the best. So thank you for Law Pods for providing that platform. So Gary, on these questionnaires though, obviously if you're dealing with like 60 jurors, you got a ton of data. And I imagine the judge isn't going to give you like 2 days to read it all and then come back. So how are you going to first off read, analyze, interpret all of that information in the short amount of time?
Yeah, the bottom line why the judges don't like them is because you need overnight to photocopy them and distribute them. So you always have overnight because you might do a session in the morning and a session in the afternoon. You pick up 30, 40 jurors in the morning and 30, 40 in the afternoon. Or if it takes multiple days and it's one panel a day, you end, you copy, and you distribute. So I make sure, personally, I like paper, sorry to the trees, but I get a hard copy of all the questionnaires delivered to my house immediately. I evaluate them 1 through 5. 5 is the best. 1 is the worst. I do pluses. It's a 2+ or a 3-, that kind of thing. And I do that on the top base page of every questionnaire based on the content of the questionnaire. I highlight using a highlighter things that are important. I write notes on them, ask about this, prior accident or excessive jury verdicts, whatever it is. So I then take the questionnaire information and I move it to the sheet that I have in front of me that I'm using for voir dire so I can move more quickly about the jurors. And then before I lock it in, I will still pick up the questionnaire. Right? We didn't cover some of the basics that I know most folks know, but when you're picking a jury shortly into the process, whether it's through questionnaire or orally in voir dire, the strong plaintiff jurors are identified. The horrible defense jurors are identified. It's the middle group that you're not sure about. And those are the ones where you need to spend your time. And on those, I'm going to pick up the questionnaire while I still have time to ask questions. And I'm going to flip through the pages right in front of them. I'm going to tell them, I made a few notes, things I'd like to ask you about. And then I will take my numbering system, try to sort of finalize it, because the defense still has to go and I might change it again. And then when I get to, let's say it's a 4, that's my final number. If I'm sold on them, I circle it. And I put a yes that I want them. Or if it's a 1 or a 2, I circle it, meaning I'm sure. And then I put a yes or a no. And then I put the order that I'm going to use my peremptory challenges because I know the defense might use some, or maybe there are a 2 or 3 and I'm not 100% sure which way to go. And then the next ones coming in are either great or terrible. So it changes, but you need a good system. You need to be organized. And you need to spend the time. And also, maybe this is a different topic. We got a little bit off of questionnaires, but you can use publicly available electronic data to search these people. You can go on different social media things as long as it's public. So we use everything available that night. We work all night on it, not all night, because I believe in getting a good night's sleep before each day of trial, but we work hard. And the questionnaires can be real helpful, and it helps you organize and structure how you're going to go at the oral voir dire the next day.
Gary, let me ask you this, though. What do you do when, because I know we've all been here, I'm sure you've been there before, where you're like, okay, I got my plan, I got my 8 1s that I got to strike. Oh shit, I got 6 strikes and I got 8 1s or whatever, or 8 1s or 2s or whatever. How do you go about figuring out who are potentially the 2 jurors that I got to live with and not strike?
Well, sure. What you're trying to do with all the defense jurors and the negative jurors, obviously, is you're trying to get cause. So my voir dire is to figure out the ones I'm unsure about, to get cause on the ones I'm sure I don't want, and to insulate and protect the good jurors that I know I want to keep. So the good jurors, I remember I had a woman once on my panel with a seeing eye dog, a blind woman who was the kindest, sweetest, nicest person. She spent her time on a help line on the phone, helping people in distress. And she was an older woman, and I just loved her. I just would do anything to get her on my jury. And so I said, ma'am, would you like to be on this jury? She says, oh, heavens, yes. Have you ever been on one? Oh, no. Once in my life, I was hoping I could do this. And would you like this to be that one in a lifetime chance where you finally get to be on a jury? Oh, yes. And you think you'd be good and fair? Oh, absolutely. The defense is looking at me like, you son of a bitch. Sure enough, I've told people before, she was on the jury. I won 12-0 with the dog like this at the end. I won him too. So try to get cause when you don't have enough peremptory challenges. It takes time. These judges say you can pick a jury in 15 or 20 minutes. No, you can't. You can't figure out enough about people, and you can't figure out if they have a bias to the level to prove to the judge. If the judge wants to pick a jury in a short period of time, then his standard for bias should be, yeah, I think I have a problem being fair. But most of them don't let that suffice. You have to pursue it, and you have to establish how strongly they feel that way. One of the things you can use a tool to save time is when someone says to you, yeah, I kind of have a problem with lawyers or lawsuits or whatever it is. You say, okay, on a scale of 1 to 10, how strongly do you hold that view? And that's a very good way, quickly. They say, oh, it's a 10, it's a 9, it's an 8, it's a 7. So very, very strongly, you deeply hold this view, yes. So sometimes switching over to ask the juror to self-assess on a 1 to 10 basis can be a helpful way, but cause is critical. I tell jurors, when you talk to someone, I talked to Rosh Hamapur, he got a great verdict on a very hard case. He told me the judge gave 26 challenge causes during jury selection, 26. Well, isn't that the difference between a plaintiff verdict and a defense verdict, maybe 2 or 3 times over? If the judge didn't give him any challenges for cause, he had a disaster on his hands. But by granting the cause challenges and getting a fair panel, it was a totally different outcome. So cause challenges are essential, and lawyers need to know how to get the jurors to admit the bias and to get the judge to understand what the proper standard is.
But what do you do, Gary, when we've been in that situation where you got 12 bad jurors and you're going, I got to get cause, and you do, but then you wind up with maybe one more bad juror than you got for cause because you had a judge who was just, they're sitting there, they're worried about how many jurors they have left in the back, and they start denying a couple. How do you decide, what is it that you're looking at when you're deciding 7 of these people are like Fs or 1s? Which one should I leave on there?
Well, I think that one of the things people have to be careful about in what we do is too much generalization and too much stereotyping. I don't want an engineer. I don't want a computer scientist. I tried a case out in San Bernardino, extremely difficult case. They wouldn't offer me the $500,000 policy. My client was shot in the stomach by gangbangers and lost both legs due to the lack of blood flow. So bilateral amputations on an 18-year-old. And I was suing for negligent security, that the security guard should have done more, should have seen these gang members and done something to protect my client or kick him off the property. Hard on every level. The case was trifurcated. But I knew one thing. Damages were never going to be my problem on that case. I have an 18-year-old with no legs. The most conservative juror in the world was going to give plenty of money. My problem was liability. 100% was my problem was liability. So when I picked the jury, I took a guy who had served in the war, Vietnam. He was a 20-year Marine. I took a guy who was a first responder, firefighter. I took a guy who worked up on the pole for SBC or whatever that phone company. I took all these strong defense jurors. Their professions would be terrible ordinarily for a plaintiff. However, what they all had in common was my theme of the case. If somebody doesn't do their job properly, someone else might get hurt or killed. So when I was talking about this security guard who saw the gang members, identified them as gang members, and went the other direction because his shift was over in 10 minutes, all those jurors were strong plaintiff liability jurors. When it came to damages, I asked for $70 million, I think, and they were hung for 3 days. I thought, oh no, I'm in trouble. They were hung because the conservative ones only wanted to give $50 million. And the plaintiff jurors wanted to give 70 something million, and they ended up at 50 or 60 million dollars. But so you have to look at that bad juror, as they refer to them. Why? And can you connect with that juror? Can you, based on who you are, who your client is, the theories presented, can you take what might be a conservative defense juror and turn them around because your side is righteous, because the other side's not taking responsibility? So there's reasons why you don't like all the various jurors you don't like, but within that broader group of I don't really like this juror, which ones do you think you can reach? Which ones are fair-minded? Which ones may have conservative views, but at the end of the day will truly follow the law and will probably listen and give a decent award? And then, of course, as we tell even the most basic person experience level picking a jury, you got leaders and followers.
I was just going to say that. It really could just be as simple as that. And cause I picked so many juries with Harry, and there's a juror I'll be worried about. I'm like, man, like we got to get, he's like, she will not have, or he will not have any influence in there. They're just going to ignore him.
Or they don't care, right? You got the
stoner who's like, I don't,
well, whichever gets me out of here sooner.
Yeah.
Right.
And there's also this distinction I always make between, when you think about leaders, like there's the leader who is going to have some credibility with the other jurors because they're like present themselves as like, I'm super fair and it depends on the evidence, and they don't have any real biases that they talk about. And they're like in a position in their jobs where they kind of know what they're talking about, like they're a manager or something. And then you have ones who are just like loud assholes. And you're like, how can I keep this guy in the jury? But if you're down to your last choice, sometimes I've left that guy because I'm like, the other jurors are going to hate that guy.
Yeah,
they're not going to listen to that guy. He might be a young, obnoxious guy or just someone who's just obnoxious. And, and sometimes they pump up your damages because they piss off and polarize the other jurors. So think about, like, are the other jurors going to actually listen to this person? Are they a real leader, or are they just a loudmouth?
You want to hear something interesting? The last trial I just finished a couple weeks ago, I was in trial 5 weeks on a hard case, Gibson versus Universal Studios. The parking arm came down and hit him in the head. You got two issues. One, why is he in the street where he gets hit by this parking car arm that comes down? And two, how does someone have a mild traumatic brain injury from being hit? So I'm picking the jury. We used a questionnaire. It took a while. Judge Schaller was very, very good judge, very fair to us. So I get the jury. I'm pretty pleased with the jury. I like them. And case is going well. With all the issues I had, case going well. There's one juror there, I'd say late 50s, maybe early 60s, works in some sort of business side of healthcare. I liked him. Each day, you can't talk to the jury, of course, but when I walk down the hallway in the morning and I see the guy, he's looking at me like, I get a good vibe. When I'm carrying all my boxes, he's looking at me like, oh, that's a tough load. Oh, I just got a great feel from him. His questionnaire said he was born in Israel. He's Israeli. My wife's Israeli. She comes in to watch my closing. First break during my closing, she says, what about juror number 2? I said, oh, he's in. He's good. He's Israeli. She said, yeah, no, he's not. He's against you. I'm like, what are you talking about? The guy loves me. She said, no. And so turns out he's the foreperson, 100% against me, 100%. Now I got a great verdict, 7.6 million on that case, and like 10 times or 15 times the offer, but she was right. And I asked her, my wife, who's a new lawyer, brand new lawyer, she's never done trials. I asked her, I think I knew why once it happened. I didn't see the train wreck coming, but she's like, hey, in Israel, Israelis, their attitude is, you got to look out for yourself. Everyone's trying to kill you. Everything's dangerous. That pothole didn't cause your injury. The idiot that stepped in the pothole caused his injury. The arm coming down wasn't the arm's fault or Universal's fault. Get out of the street and stay away from falling objects. It's all your fault. They don't believe that you blame anyone else. It's like we talked about earlier, that handyman that makes sure everything is safe for him and doesn't trust others. Israelis have that mindset. And my wife, being Israeli, spotted him and spotted it right away. And as she said it to me, I thought, yeah, son of a bitch, you're exactly right. However, I don't think he was malicious about it, but he did, as the foreperson, I think I got 7.6 million. Without him, I think I had a runaway. Now, I don't know, but I could have run away for 8 figures. And he got 13% fault on my client, comparative. I think he was the one convincing the others to put some fault on him because he wasn't happy about 13% either. But the point being, one bad juror who's against you can sometimes also hurt, but I just didn't see it coming. And Harry, when I told you about it, we were sharing stories because we all live and learn from each other's trials. You were thinking that as a generalization, you were talking about Australians
They're
and
kind of
New
the same
Zealanders.
way. Yeah, Australians are kind of the same way. They live in a pretty dangerous country. A lot of dangers in Australia. They're pretty tough people. There's no warning signs or regulations there, and they're just like they come here and they're just like, "What the hell is wrong with all you people? Like, just keep your eyes open. There could be, there could be a crocodile or a snake or a deadly spider wherever you're going. So it's all on you. What if the government doesn't keep you safe? So and they think it's ridiculous. And a lot of countries are the same way. And it's funny, Gary. It brings up a funny story, that guy's reaction, because I remember I was picking a jury a couple of years ago on a case where a sprinkler on top of like a big bamboo thing that we used to water a park just fell down, bonked him in the head, cracked his head open and everything. And we had this one young juror going, "It's your own fault if you're standing under if there's anything that could fall on you, if you're standing under, it's your own fault." And I'm like sitting there and I'm looking, and she's sitting there in the courtroom underneath this fluorescent light fixture. And I'm like, "What are you? So like, are you an idiot but they think that way. You don't argue with them, just get rid of them."
Yeah, I mean, that's a really good point, Harry. That some lawyers think that you're going to change people's views. They've held that view on the low side for 20 years, on the higher side 50, 60 years, and you think in the next 3 minutes, by asking them a really good question, suddenly they're going to be like, "Oh my God, I was so wrong about that McDonald's coffee case for so many years, but now that I'm talking to you, absolutely, millions for everybody." No way, man. They're
Yeah.
not changing their minds. They're not changing who they are.
On that note, I do want to just kind of a final topic here is really how do you talk about money in jury selection, Gary? What are the different ways you introduce it? Do you give a specific number in mini opening? What is your method that you found to be really works well now?
Well, I think that's a great question for everybody that comes onto your program, because it's some of the hardest things to do and probably the most important, right? When I lecture on the subject, what I explain to lawyers is whatever you're asking for, and most of the time you're trying cases, you're asking for either hundreds of thousands or millions or multiple millions or tens of millions or 100+ million. If the jurors philosophically, based on their life experience, are opposed to awarding millions of dollars, for example, or tens of millions, I don't care how good a lawyer you are. I don't care how good your facts are. I don't care how smooth you are and how artful you ask your questions on direct and how sharp your cross is. You ain't getting it. They don't believe in it. They're philosophically, emotionally, their life experience is against it. You will never get it. So what we're hoping to find is a group of jurors that are truly open to the possibility that millions or tens of millions of dollars might be fair for a particular loss or harm. So I, again, strongly recommend not going into a topic like this anywhere until, let's say, at least the midpoint of your voir dire or a little more, because they got to be really comfortable. You have to have established some credibility. You have to have established a nice question and answer flow. You have to get an idea for who's who and what's what. And you need to warm up. You need to get, like, sometimes you stand up in jury selection and you're all screwed up and sorry and stumbling on yourself. So once you settle in, I talk to them about, I talk about lawsuits. I talk about if they've had any and their experience, maybe fighting for their rights and things. And then I might say something like, and these are questions that the answers are meaningless, but you're saying it for them to hear you, like things like, does anyone have a problem with the idea of awarding money for suffering? And I let it hang out there because they're like, what's he asking me? Money for suffering? Huh? And I'm just saying that so they think about it. And I'll say to them, you understand, because the defense is going to tell them, if the plaintiff doesn't prove his case, can you give him nothing? So I always start with, you understand, defense is going to tell you, if the plaintiff doesn't prove their case, accordance with the law, you'd have to award zero. Can you all do that? And they think, oh, say, he's very fair. He's telling us to award zero if he doesn't prove his case. That's very reasonable. And it's true, and that's the law, and they're going to say it, so you might as well say it first. And then I ask them about the concept. If the plaintiff does prove their case, can you award all damages that are fair? And they say, oh, well, that's reasonable. But I'm showing them the idea of all damages that are fair. So now I'm getting more credibility because all I'm asking them to do is award damages that are fair. But then we need to talk about what fair is. Do you think that in some cases fair could be zero, could be $1,000 or $5,000? But on another case, ma'am, what do you think of the idea that fair might be $1 million or 10 million? Or, sir, given, I'm asking in concept, do you think you could keep an open mind to the possibility, depending on the harm, that fair damages for suffering may be over 50 or $100 million? Now I'm introducing slowly, subtly, 50 or $100 million, and then I'm gonna have a big discussion about it. And I'll tell them, who thinks it's crazy? Who thinks I'm crazy? I said 50 to $100 million or over 100 million. And I'm going to get that discussion going and I'm going to get them talking about it, but it's going to be hung or framed on zero if I don't prove it, only the damages that are fair, and then all the damages that are fair. And at the end of my case, in closing argument, I'm going to remind them of that discussion and say all damages that are fair and the possibility that it may be 50 or 100 million. And so by doing that, I'm having an open, frank discussion about zero and $100 million. And, you know, to those watching, don't say $100 million on a soft tissue chiropractic case, but it needs to be somewhere in the realm of what you're thinking about. Maybe it's $1 million.
If a juror then says, well, what are you going to ask for in this case? How do you respond to that?
I say that at this time in jury selection, we're actually not permitted to talk specific evidence and specific numbers. So my question to you is about the concept. And I go a little further. Is there anyone here, sir, you work for an insurance company. Would you not want to go back to work having awarded tens of millions of dollars? How would you feel about that? Or I ask them, sir, you've said you think there's too many lawsuits. Do you think that you would be less inclined to award that amount of money, even if we prove it? Would anyone here hold plaintiff to a higher standard than the law provides if, in fact, we were looking for an amount of $50 million or more? Now, rarely do you get a hand up, although sometimes you do, and that's very important. But I want them to understand and think about that you can't do that. And so sometimes I'm educating, sometimes I'm being educated. It's both. And that's how we have to handle it. It's both. You know, in terms of general information, what you asked me about what I've learned along the way, and I think it's an evolution or a progression of learning. In the beginning, I'm just trying to survive. Later, I'm just trying to make sure I ask the right questions and I hear the answers. In the beginning, you're too nervous to hear the answers, so it helps to have someone else there that can hear the answers or at least tell you. And then you start getting to the point where you're able to be more comfortable in front of the jury. And so for a while there, I spent a lot of time selling myself, selling my credibility, selling my comfort, my knowledge. I can be a little bit funny. I can be a little bit serious. I can talk to them about whatever subjects they bring up. And it was the Gary Dordick show. And oftentimes I get so many pats on the back. Wow, that was amazing. They loved you. They responded, they laughed with you, they cheered with you, and you sat down, they were all so happy. But then I was like, yeah, but I didn't learn shit about them. I was so busy being entertaining and being credible or funny or whatever it was that I really didn't spend enough time to get to know them. So when I sat down, I'm kind of like, oh, you, and just hoping their fondness for me or my ability to entertain or my connection would be enough if carried throughout the trial and I gained credibility along the course of the trial. But I've learned that it's much more important. Your credibility is important, but I have to really see how they think about things. I have to give them a chance to talk and tell me what they're thinking about important issues. Like I think with that juror who was the foreperson in my last trial, that if I would have asked him a few more questions about, tell me what you think about suing the owner of property for a dangerous condition, that bias would have come out in some of the choice of words he used, the way he phrased it. After a couple of sentences and discussion back and forth, I would have seen the bias. It didn't come out on the questionnaire, but the questions weren't suited for it. I never asked him the right questions to hear how he really feels about premises and property and lawsuits. So I think it's important to really try to ask good questions. And Harry, you know, that's where jury consultants come up. People think jury consultants, that really what they're doing is using your superpower to say, get rid of him, get rid of him. No, yes, this one, no to that one. But they don't understand that you're helping them frame the case. You're helping them discuss and decide which questions to ask. You're teaching them, ask more to that juror. Get me more information here. Ask them this question. You're helping them elicit information that then helps you and them make better decisions. But the better decisions come from figuring out how to get jurors to talk to you on the important subjects.
100%. Yeah. I mean, sometimes people think that we're just mind readers and we can just kind of look at a juror and you ask them a couple things. What are your hobbies and what is this? And then what do you think of him? How do you think he's going to feel about, police brutality or employment issues or whatever? And like, we're not mind readers. I can hear what someone says on topic and tell you, I think this is how he's going to feel. But I always tell lawyers, you never want to get back there during a break after you're done with your voir dire and say, I think we got to get rid of this juror because I just worried that he's an accountant and therefore he's going to feel this way. Well, if you feel, ask him that. I'm worried he's not going to be able to award damages without a formula. Ask him, how do you're an accountant. You deal with formulas all the time. How do you feel about awarding money for quality of life without a formula? And he may tell you, there's no formula for that, and I'm okay with that. It's valuable. Or maybe he'll tell you, I know it's income is the only thing I can award. So you got to ask. You don't just assume if you have the luxury of voir dire.
I'd say that, in terms of catch-all, so, everyone has their own way of finding out information, but you get to jurors sometimes that you've asked the right questions and you're not sure about whether you should keep them or not. You're still just stuck. They're not great. They're not terrible. You've got 6 challenges. Where am I going to use them? The questions I like to ask people, which are sort of generic, but if you ask somebody how they enjoy spending their free time, I'm not going to ask everybody that because I don't need to know about the ones I'm already sure of. But the ones you're not sure of, how they spend their free time, what hobbies and interests they have, and sometimes what public figure do you most admire? You have to ask public figure. Otherwise, you get their father, their sister, or, sometimes you still get Mother Teresa. But it's telltale when they, depending on what's going on in the world and things, who they most admire. So you get good information. And this is something I think folks that know me know well. But I always end my jury selection asking if there's anything that we need to know. And the example I give often in trial, it's kind of funny, but it's a true story. I say to the jury, thank you, and I'm just about done, but I have one last thing I'd like to ask you. I tell them that I was in a trial once and the jury returned a verdict 11-1 in favor of my client. One person did not see it the way we thought. And I was a little surprised. So after, as we're allowed to do with the court's permission and your permission, I asked that one juror, I said, ma'am, you didn't vote for my client, but the other 11 did. Could you share with me your thoughts as to why you didn't? She said, oh, absolutely. It was very easy for me because you reminded me from the time you first opened your mouth so much of my ex-husband. I didn't believe a word you said through the whole trial. And I said, oh, well, okay, but ma'am, why didn't you tell me that when we were picking the jury? She said, oh, you never asked. So, for all of you on this prospective jury panel, is there anything that I should know about you that I have not asked that might be important? And it's funny, it's interesting, it's true, but you sometimes do get people to say, well, yeah, I didn't mention this, but blah, 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 blah. Or at least you've covered your bases by asking, and obviously, you want to go through, people want to go through all the basics. Have you been in a lawsuit? Have you been sued? Have you had some people only ask lawsuits, but they need to ask, have you had a claim against you? Have you been involved in the work comp system? Have you been a witness? Have you been an expert? All of those basic foundational questions are essential information that you get from a questionnaire. But if you don't have the questionnaire, you need to ask those essentials. Then those last catch-all questions I've suggested, you ought to have pretty good information to make some good decisions.
All right. Well, this is just all. I mean, I could keep listening to this for another 2 hours.
You mean we're not?
But,
I'm about to crack a beer and we're just getting warmed up, man.
I know, man. I know.
We'll have to continue it some other time.
100%.
Yeah, we'll definitely bring Gary back for a part 2. This is great, super educational. I mean, I always learn. I'm just sitting here taking notes on what I'm going to do in my trial coming up. Thank you very much, Gary. It really is a pleasure. I appreciate you always being here for all of us to learn from all your experience. Harry Plotkin, any final words?
No, I mean, I'm excited to sit down with Gary again and do more. I mean, there's a reason that even I remember one time we were picking a jury, even the security officer checking us in at the courthouse knew that you were the godfather of plaintiff lawyers. So, always a pleasure.
Well, thank you guys. I think it's great what you're doing. You guys are a wonderful team. You got the best of the best out there in terms of Dan as a trial lawyer, and Harry, I think you might even be surprising yourself how truly phenomenal you and your wife Claire have been doing and the verdicts you've been on. I mean, sometimes when I see there's a $400 million or $500 million verdict, you look and you're like, Harry again. So you've really set the standard for jury consultants. I know I love working with you. And, people say to me, I know it's over here, but I've picked between 150 and 200 juries. I know what the heck I'm doing. And I still contact Harry to come work with me because he's got that knowledge and that experience. And it's just great I've picked hundreds. He's picked thousands. So it's great. Yeah. It's great what you guys are doing. I'm happy to come back anytime.
All right. Thanks a lot, everyone. Thank you to Law Pods for making this all possible and making it really easy for everyone to get all this great information.
Sounds good. You guys take care.
Awesome. Thank you.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.